Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Docketwise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like Docketwise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, Docketwise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about Docketwise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy day after Thanksgiving to everyone. I hope you've all fully recovered from your respective feasts. As we digest, I thought I'd publish a special episode of the podcast, an interview with retired immigration judge Zsa Zsa DePaolo. I spent 2 years working with Judge DePaolo and many other immigration judges in the San Diego and Otay Mesa immigration courts, and I feel exceptionally lucky to count Judge DePaolo, as well as a handful of other judges, as my mentors. Judge DePaolo and I spoke, socially distanced of course, the evening before Thanksgiving, discussing her professional background and path to the bench, her personal views of immigration law, best practices for all attorneys to consider when appearing in immigration court, and her life since retiring after over 20 years on the bench. I hope you all find it as enjoyable and helpful as I did. Thank you, Judge. Now, on to the interview. Welcome to the special episode of the Immigration Review Podcast. I'm Kevin A. Gregg, and I'm here with former immigration judge Zsa Zsa DePaolo. Judge DePaolo was an immigration judge in Otay Mesa in a detained facility for over 20 years. And I'm really, really honored that she decided to be on the podcast with me today. We're going to talk about a lot of things, including best practices for private bar and DHS attorneys when appearing before immigration judges. For everybody's record, it is the day before Thanksgiving, November 24th. I'm not quite sure when this will drop in the podcast feed, but happy Thanksgiving to everyone and happy Thanksgiving to you, Judge. Thank you, Kevin. Thank you for having me. It is my pleasure. I'm honored that you decided to be on the show. You know, before we get started, I just wanted to say one of the things, in addition to your brilliant mind and all of your immigration knowledge that I learned from you while I was working with you, was kind of how to view these cases in immigration court. I was only behind the bench for 3 years, 2 years with the immigration court, and of course I wasn't a judge, but you know, maybe you'll agree with me, maybe you won't, but when you see so many cases, there's a tendency to look at the cases as just paper. Think of yourself as your finger in the dam, preventing it from exploding. And for me, and only being behind the bench for 3 years and not even being a judge, I had to fight that every day. And I learned that from you. I also learned from you, and this is almost just your language, the idea that we as a country have not really discussed how we treat individuals in this country without authorization. At what point do these people become the responsibility of the United States? At what point are their potentially criminal activities the fault of the society that they live in, the United States? At what point are they ours? Immigration law doesn't really account for that question. You know, maybe we should. And so I thank you for that. And I don't know if I explained your theory on all of this or your beliefs on all of this well enough. So if you could expand on that, I'd really appreciate it.
Yeah, I started in my career. I started doing cases down at the Otay Mesa Port of Entry, and people would come over across the land border there and be escorted to court, where I would hear their cases. So those were the non-detained cases that I would have dealt with at the time. Other than that very short period, almost all of the work that I did was with the detained populations at the Otay Mesa Immigration Court. They would also bring people over from the state prison, or immigration judges would go to the state prison and conduct those kinds of hearings in the facility itself. So I had a lot of contact over the years with a lot of mostly men, many of whom had been in the United States since they were small children. And they got into trouble, and the majority of them had some kind of a criminal record. And I obviously had to determine whether or not they were subject to deportation or removal, and whether or not they were eligible to seek relief. It's difficult to see the whole picture in immigration court sometimes, but I've always felt that I had a great respect for the law and a great deal of respect for the people who come before the court. And I always tried to make personal connection with anyone who came into my courtroom who was facing deportation from the United States. A lot of these individuals were young men who spoke fluent English. Many of them did not speak Spanish, and they grew up in the United States. In many ways, families that are suffering from poverty also have issues, as most families do, with drugs, alcohol, family violence. So they're difficult cases, but I also really got the feeling after a while that I was deporting people who had no relationship to the countries where they may have been born in before they were brought into the United States. And of course, the majority of the countries that we were dealing with the detained cases were many people from Mexico, El Salvador, Honduras, and Guatemala. So a lot of Central Americans. And it's ironic it's ironic that the United States was in the position that they supported many governments in Central America in the 80s and 90s, countries that were involved in civil war, and with many governments who mistreated their population. There were political differences. And because of the wars, many of which the United States participated in or funded in some way, there was a great migration out of Central America, and many of those individuals from those countries came to the United States. A lot of those young men who I met in the detained setting where I was working were young men who, as I said, really considered the United States home. And I very much often felt as if I was deporting young men or even women who really had ties to the United States, was raised in the United States, was educated in the United States, got into trouble in the United States. I think there's always going to be a certain percentage of people who are very dangerous, who need to be removed from the United States. Other than that, I'm not convinced that many of those individuals who I deported were going back to countries that they had some relationship with. Many of them didn't even really know their families in some of those countries. And I would say to some of these young men, I know that you're going to a country that you have no relationship with. And I have said to many of these men, you really do belong to us. You lived in communities here, you went to school here, you got in trouble here. And of course, with the ever increasing number of crimes that are considered aggravated felony offenses, many of these individuals who might have minor drug offenses would find themselves being subject to deportation and removal. Many people would say, I was born here. I thought I was many people said, I thought I was an American, that my parents brought me here. And since I've lived here my whole life, I thought I was a U.S. citizen. And then you have to break the news that I'm sorry, but you're not.
Right.
I also, when I first started doing immigration work, there wasn't the kind of expansive criminalizing of the immigration laws. When I first started doing immigration work, the majority of the cases that we did were legalizing farm worker families and defending deportation and removal cases with suspension of deportation.
I don't want to age you, Judge DePaolo, but that would be around the 1980s, correct?
That was around the 1980s. The legalization laws that came out, I think it was 1986 that happened.
Yeah. I want to get back to the criminal stuff in a bit, but I guess that's a good place to start. And so what is your personal and professional background? What led you to immigration and what eventually led you to the bench?
Well, after I graduated from law school, I did some work in the juvenile division for the King County Public Defender's Office in Seattle. Also worked at one or two other public defender's offices. And I really was my passion at that point was criminal law. I kind of fell into immigration. My sister Christina and I decided that we were going to take some time off and we were going to go to Mexico for the summer. We started in Cuernavaca, where we took Spanish for a week, an intensive Spanish program, so that we could take buses to the beach, to the Yucatan. And when we came back from our summer in Mexico, I had left the job that I had working for the Washington Appellate Defender Association. Thought, well, I'm going to look for a job where I can use my Spanish. And I applied for a job with a nonprofit organization called the Hispanic Legal Aid Program. And they had a director who had gone to law school but hadn't taken the bar and didn't have the right to practice. And apparently they had a whole bunch of cases that went up to the Ninth Circuit Court of Appeals, because in those days, when you filed an appeal with the Ninth Circuit, you were given an automatic stay of deportation. So whatever attorney they had working for the organization before I got there had filed any number of frivolous cases, and I was really hired and had the offices back before they were sanctioned, monetary sanctions for filing frivolous appeals. So I started there, and while I was there, the new immigration law in 1986 or 87 came in with legalization, and then we worked in the community and in our office with legalizing many of the farm worker families who were in suspension of deportation proceedings before the Seattle Immigration Court. Because I was working in the court defending immigration cases, I knew the immigration judge in Seattle at the time, and his name was Judge Nail. And
what a name for a judge!
I know. Everything was so small at that time. And Judge Nail would say to me, you know, you're working for a nonprofit organization and you're not making any money. So he really encouraged me to apply for a trial attorney position. And up until that point in my career, I had only been a defense attorney. And I had real second thoughts about it. And I ended up filling the application materials and then putting them aside, because I've never been a prosecutor. I think I'm just a defense attorney. And my friends encouraged me to go ahead and apply. They all said, you don't have to take the job if you don't want to, but you should at least apply. So I applied and I was interviewed and they offered me a position. And I think my first day at work, the building we were in Seattle was down on Airport Way South, and it's a historical building, but it's concrete. And I walked into an office that almost looked like a jail cell. My first day of work, and all I could think of is, what have I done? But I actually had a really positive experience. Like I said, this was starting in 88 to 95. I did a lot of different kinds of work. So I had that position up until 95. And that's when I had the opportunity to apply for a position as an immigration judge. And I was fortunate enough to get that position. And that's when I really started doing a lot of detained cases at Otay Mesa.
Thank you for that, Judge. I have two questions based on that. You've had quite the career. And that there's always, at least for me, and I think a lot of people, especially the listeners who are at nonprofits, or the listeners who are with the government, there's all the question about if you want to advocate for immigration issues, for proper immigration issues, or any issue, is it better to do it from the outside, to really push the government to be able to be an advocate and to really push for what you think is right, such as what you were doing with the nonprofit? Or can you get more done by being on the inside and being a voice of reason in the U.S. government to be able to exercise your discretion? What's your thought on the best position for someone to do good in the United States?
I think in both places, outside systems and inside systems. I encourage both forms of participation. I've always said to myself, I have to be able to be who I am in any job that I have. So genuine and authentic. And I really felt an obligation to every case. And I think in terms of practicing, I always tried to look at more than the issue of, number one, is this person subject to deportation? And number two, are they eligible for relief? Many of the individuals whose cases I heard came from families who came to court and really cared about the outcome of the cases. And I many times really felt that if I had not been there to decide that case, it could have resulted in a very different ending story or ending experience for the person who was in removal proceedings. So I would say both.
Thank you for that. I think it should be both too. Before we get to the best practices for practitioners, I'd like to talk just a bit about the criminal stuff and the way immigration law is structured. You know, in criminal law, there are a lot of flaws in our criminal justice system. But with criminal prosecutions, there is discretion at all stages of it, whether to bring the charge or not, what type of charge and what type of sentence to seek, and then at sentencing with the criminal judge, what type of sentence to impose, whether all of these things, with an idea that you look at the entire person, to look at the entire spectrum of that individual. And immigration law seems to not do that. It seems to be very black or white. Now, it is the immigration bar's job to blurry that line and to make creative legal arguments. But it doesn't seem like we care so much, at least right now, about the whole individual, but rather about enforcing black and white rules. Why do you think, do you agree with me? And why do you think that immigration law has developed differently than, say, criminal law in that regard, if you do agree with me?
When I first started doing immigration law, the Immigration and Nationality Act was probably a third of what it now looks like. And the majority of people we had come through the program for legalization were not always people who'd been convicted. But every time there was a new immigration law, there seemed to be a greater emphasis or more emphasis on the underlying criminal nature. And it's always, it's easy to see things in black and white. But in reality, mostly everything is gray. But I think for a lot of people or a lot of judges who are doing cases and a lot of attorneys, there is a tendency not to take the whole person into account in dealing with removal cases. I think the law really started to address more and more the numbers of individuals who were getting arrested and convicted of crimes. When I first started immigration law, we didn't have a lot of criminal cases. That was something that really changed when it became illegal to work in the United States. I think one of the things that we can all agree on is the majority of people who come into the United States are doing so in order to improve their lives, to improve the lives of their families, to become members of a community, and to be free from whatever it is that the poverty or the racism or the political situation in their own countries. And most of us can agree what people really want in their lives. They want to be able to work. They want to be able to raise their children. They want to be able to have a safe place to live and work. And when the immigration law came out in 1986 and made it illegal to work in the United States, it became a lot more difficult for individuals without documentation to work. And that started the whole employer sanction aspect of the law. So I always thought that one of the prime reasons why there was such an increase in criminal cases coming into the immigration court was because it became so much more difficult for people to work. And in many ways, because of the inability to put a life together, you had more stressors on the family that had to do with poverty, that had to do with employment, that had to do with family violence or drugs or alcohol. And that seems to have just increased over time. And it's increased over time because of the way that courts and immigration judges define aggravated felony offenses. It's amazing to me that in many ways, individuals who have been convicted for fairly minor crimes can be subject to deportation without an opportunity to ask for relief from deportation. So, I mean, seeing it black and white, as I say, I think is the easy thing to do. To try and look at it more broadly, many judges might say, well, it's not my job to look at it more broadly. It's not my job to be concerned about where this person came from or who this person's family is or how long they've lived here. I really think or thought that it was really important to learn about whoever was in the courtroom whose case was being heard. And that meant you have to touch people in some way. You know, I always really felt like I had to touch a person in terms of understanding who they are, what their lives are about, and giving people the opportunity to speak, the opportunity to explain, the opportunity to share what are really important lives. Every life of an individual who's in deportation proceedings has to be respected and understood. And I tried to do that with every case that I had. You know, immigration cases are not, I've never felt like immigration cases are supposed to be adversarial in nature. And that's another thing that happened as the laws have changed over the years. There's just been a much larger stage for the courts and the government to criminalize individuals who are here without documents. So yeah, I think you have to try and see the whole picture and not just the black and the white.
Just such a big issue, all of it. And I can attest the 2 years that I did work with you and the other judges in the court, I can attest that you did take every case to heart. And you did make it your life, Judge. So what are some of the things that successful practitioners on either side did before you in your court and your over 20 years on the bench that you think practitioners could do to succeed in court? And what are some of the things that if, you know, when you're sitting there and not speaking, you were thinking, I really wish they had done this? What's some advice that you could give to the listeners about how to present your best case in immigration court?
I mean, I always had simple rules because I thought that my influence as an immigration judge and the standing that I had as a judge gave me incredible responsibility to do the job in the way that I thought it was required to be done. And I always lived by saying you have to be authentic, and whether or not you're an immigration judge, you're a human being. So being authentic, also knowing the case really well, and in fact, knowing more about the case than anybody else in the room. I was terrified if I didn't feel like I had a grasp on what the issues were and what the arguments of the attorneys were going to be. And so it takes a lot of work. It's a lot of work to prepare a case really well and to understand the case, particularly as we came into the era of cases where the majority of cases are now asylum cases. And that puts an incredible responsibility on an immigration judge to learn about the country where the person came from, to learn about all of the issues that are impacting that country, so that you have a way to assess that individual's fear of returning to their country. It's a lot of responsibility. But I think really for practitioners being well prepared and also thinking outside the box. I would sit in court and hear people argue, and I would think, why isn't somebody making this argument? I really encourage people to be creative, to think outside the box, and to be really well prepared when you're going to court.
Yes. Yes to all of it. How important did you find written legal argument?
Written legal arguments. It really depends on who the lawyers are. There are some lawyers who cut and paste a lot and do that kind of a presentation in court or provide documents where it's obvious that it's canned canned law, and the arguments are really on the surface sometimes, or there were lawyers who gave written work that was exceptional. Your reputation as a lawyer is really important because it has to do with trust. And if you want an immigration judge to trust you, and if you really want the judge to really rely on what you say, you have to be consistent, you have to be creative, and you have to work really hard. Because I very many times would get written material that didn't inform me of even the theory of the case for the individual attorneys. And this is both respondents, lawyers, and the government. You have to go the extra mile if you want to convince an immigration judge that you have a theory of the case that should persuade the judge to go one way or another. And I was always the kind of judge, I tried to stay really open and allow people to make arguments. And very many times I ruled on a case in a way that was not the prevailing theory of the case, or was not the prevailing assessment of the law at that point. Because I think one of the things you have to do is you have to be creative. I mean, there's something, you can go ahead and say, well, my only job is to, apply the law to the facts of this case. And if your practice is going to be limited to looking at certain cases in very narrow terms, then there's a whole lot that's missing or could be missing. And you're not going to get much progress on a case or with the law unless you prepare your cases that way. So written work, some of it, I would say the majority of it is usually canned, and some of it is really brilliant and was very persuasive. And I also allowed attorneys to make arguments in court. I don't know what other judges did, but I really felt like if it was an issue that I had concerns about and I thought, could go one way or the other, I allowed attorneys to take the time to argue the case in court.
What were the most important factors to you when deciding to grant or deny bond?
Bond is another place where there's a lot of room for, I don't know if it's improvement or what, but the majority of the people who would come into my courtroom aren't the kind of people who have thousands and thousands of dollars to get themselves bonded out. When I was working in municipal court in Seattle, I had a judge tell me, with respect to bond, you had to really realize that people didn't have the resources to pay the kind of money that they needed to get themselves out. So, and this is the same in immigration. If you can pay, then you can get out. I mean, that's really simplistic, but we have really high bonds. I thought some of the immigration bonds that were set by many judges were astronomically high, and that it kept individuals who necessarily were not a danger to the community or a flight risk, kept those people in custody because they couldn't afford to pay the bond. I always really tried to look as carefully as possible as to whether or not somebody really was a danger to the community. Is it somebody who is going to go out there and impact the lives of citizens and non-citizens alike by engaging in some behavior that is detrimental to the community? And I very often tell people, I mean, the situation with driving under the influence has become really important in immigration court because it does impact lives of families and individuals. And that's a real tough one. But again, I would always look at the questions of whether or not that particular crime made that person a true danger to the community, and were they really a flight risk. I usually gave really reasonable bonds, and the majority of the individuals who left my courtroom with a lower bond didn't get into any more or less trouble than anyone else, and usually they did not come back.
And so I guess to stay on bond for a sec, for practitioners, if you have a client with 2 DUIs or a client who does have an assault conviction, serious crimes, no doubt, but they're not murder, what type of things, what kind of evidence were you looking at to determine whether or not on the whole this person was or was not a danger, notwithstanding his convictions, which are serious.
Mm-hmm. Again, I think you have to try and look at the whole person. And that requires time. It requires somebody being able to explain themselves and then take a look at the nature of the convictions. And one of the things that I always really relied on is if they weren't serious crimes. I mean, in DUI can be a very serious crime, depending on whether the person. I always looked at whether or not the person had any kind of alcohol treatment, whether or not they had finished programs that had to do with drug or alcohol abuse. I also really looked at, was the person employed? Do they have a consistent history of employment, family ties to the community, children, parents, spouses? And you get a sense with respect to whether or not the person's a flight risk. I very rarely had people who I had granted a reasonable bond to, that they went out and violated the conditions and were back in court before me. I would say it was maybe a handful of cases. And usually it was people who really did have problems with drugs and alcohol, people who had illnesses. Yeah, they're crimes, but they're also really definite physical and psychological situations where people are just ill. But again, you have to say, when it's a balancing, it's really balancing whether or not that person can be trusted. Do they have enough support at home? Are they in a program? Will they be in a program? I mean, I think if you look at all of the really important aspects of someone's life, you get a sense of whether or not they're going to be a danger or a flight risk. Some people, right off the bat, other people you don't. And also don't forget that many of the people who came into my courtroom had no criminal convictions. They were individuals who were picked up by the Immigration Service, either at their homes at 5 or 6 o'clock in the morning, or individuals who had come into the port of entry and requested asylum. So there were a lot of people in my courtroom who didn't have criminal records, but also don't have the money, the kind of resources to get themselves out of custody. Some people do. I don't want to say that there aren't people who do. There are many people who can pay $20,000, $30,000 bonds and get themselves out of custody. But then there are very many people who cannot.
That is a good point, and I want to get to credibility in a sec, but it did just occur to me that I do have a judge who did bond for almost 2 decades. The lame duck president has said that only non-citizens with low IQs come back to court if they're released on bond. Was that your experience, Judge DePaolo?
No. I would never assume that I knew someone's IQ. I would say the majority of them do appear.
Before we get to credibility, I just have to note, I remember being in your court and observing once, you talked about practitioners thinking outside the box, and I think you did the same thing. I remember it was some misdemeanor type domestic violence thing in which I believe the state didn't even end up bringing charges, and the man's wife ended up coming into your court and testifying on her husband's behalf. And you did grant a bond. I'm not sure how much it was, but before you granted the bond, or right after you did, you looked this man right in the eye and you gave him the business about how he was getting released because of his wife and that he owed it to his wife and his kids who were there. It was because of them, and he better not screw up again. And how important that was. And so if the idea of bond is to ensure non-citizens appear in court, and if the idea of bond is to ensure that they not be dangerous, to me, that seemed like a very powerful moment. I guess you kind of had to be there. But to me, I left saying, oh, my goodness, that man will not do anything like that again.
Yeah, well, ideally, the majority of people are not flight risks or danger to the community, particularly people who are seeking asylum in the United States. And most people seeking asylum usually have some kind of family here. And then there are other individuals who have no family here, who have no ties to the community and cannot pay a bond. But you have to ask yourself, is keeping somebody like that detained really in the best interest of the United States government, or in the best interests of the person's friends and family if they have them here? So many of the cases that I've had to deal with have been obviously with people who have been convicted for crimes, and most of them from Central America. I think it's fair to say that the United States, as I said, went into many of these countries and impacted the political, social lives of many of these countries. And people from the Latin American countries then came to the United States to seek protection. And then it may be ironic, but those same individuals grow up and start to have real problems. And then we export our gang problem. Most of the individuals who have made the gang situation in El Salvador, in Honduras, in Guatemala, the drug trafficking, we really exported the gang problem into those countries. I'm not saying all of it, but people say to me, I'm afraid of the gangs, I'm afraid of the gangs. And I always say, I understand that you're afraid of the gangs, and the gangs that you're talking about are gangs that started in Los Angeles and in many of our major cities in the United States.
Right. It goes back to looking at the whole picture. Immigration law does not at all account for that larger picture. There are macro issues going on in the world, and immigration law then focuses on the individual without considering those broader implications.
Right.
What about credibility? Credibility, just every month, it seems that credibility is becoming more and more important to immigration law. And of course, no judge wants to feel like they're getting lied to. What can practitioners do? This assumes a credible respondent, but what can practitioners do to ensure that their client is deemed credible on the stand? What kind of questions, what kind of preparation, what kind of things were you looking for when making an adverse credibility determination?
It's really hard to make a credibility determination when really what happens in immigration court is a snapshot, of the person's life. Credibility, the Ninth Circuit Court of Appeals has basically, set the standard for credibility. So if you cannot direct yourself to the reasons in the record why you're finding someone not to be credible, you have to be able to say why. And many times it's not easy to say why, and I really always felt as if making a negative credibility finding was really what the case would either depend on and be relied upon in appellate review. So credibility is a tough one. Sometimes I used to say, can I just say I don't believe you because I know it's not true?
Right.
But you can't do that.
A lot of it, sometimes it seems like a matching game of inconsistency with inconsistency, and there are some consistencies, but here are the inconsistencies. And when there are so many facts with the case, the DHS's job is to create inconsistencies. How can respondents' counsel best or better rehabilitate their client on redirect when some inconsistencies have been identified?
If there are genuine inconsistencies, then it's really the respondent's attorney's responsibility to flesh out the facts that cure an inconsistency. And many times something may look like an inconsistency when it really isn't. And if the person is simply prepared well enough to testify and provides credible testimony, then I think that's the best thing that they can do is they have to prepare their clients. There are times when individuals aren't always truthful to their own lawyers. And so there are some times when lawyers are not aware of what their clients are testifying to, and they're not aware of the underlying facts because they weren't told those. So again, preparation is everything, I think. You have a judge whose job it is to make a credibility determination, and you have to prepare yourself for what the inconsistencies might be.
I'll tell you, it's that game time decision in the middle of court. Your client has just made some inconsistencies, and the decision right then and there in court is, how deep do I go? Because I don't know what's going to come out on the other side. Is my client going to tank himself, or is he or she going to come out successful on the other side. It's a difficult decision, and what you're saying is that you kind of got to take the plunge because you have to explain all of those facts, or else you're already sunk. Is that a fair assessment?
I think it is. I think it is.
Thank you, Judge. Maybe people will reach out to me after this and they'll have other questions, and maybe we can do a part 2. I don't know if you're willing. I wanted to go on to some other stuff now. More lighthearted, I guess. The case Holder v. Martinez Gutierrez was issued by the Supreme Court in 2012. In that case, Justice Kagan affirmed the BIA, held that the BIA reasonably construed the cancellation of removal statute as requiring each non-citizen to satisfy on his own, without imputing a parent's years of lawful permanent resident status or continuous residence, the statutory requirements to obtain LPR cancellation. So a child of LPR's needs to independently satisfy, I believe this is what the case holds, the 5 years in LPR status and the 7 years in any status. And I bring this case up because you were the immigration judge, correct, of this underlying decision. What was that like to be kind of the subject of a Supreme Court decision, and a Ninth Circuit one at that?
Well, prior to the new provisions with cancellation of removal, there was 212C relief and the exercise of discretion. And there was, in a case called Lepe Gutron, the holding was that children who were brought here underage could impute their parents' time as lawful residents to their children, not only the status, but also the amount of time. And that was pretty much standard. That was standard Ninth Circuit law at the time. And then they passed the removal statute, and it was an open for a long time whether or not you could still impute to the child. And I argued pretty strenuously that I thought it did. However, in the case that we're talking about now, there are times when I have to make decisions that I don't necessarily agree with, because I feel like I'm bound by the law dealing with precedent, and I have no choice but to make that finding. And this was that kind of a case that I felt is that I was compelled to deny the case, but that I thought it was a case that really should go up on appeal, because even though I was saying, according to the new law, you don't qualify. In fact, I thought it should qualify. So I did rule against the respondent in that case, and that started the whole process of appeal to the BIA, the Ninth Circuit, and then the Supreme Court. I think basically what the Supreme Court said was, we understand that this might not be fair, and we understand that maybe it could be done differently, but this is what Congress gave us, and this is what you have to deal with.
It's very interesting. I understand you flew to the Supreme Court actually and watched oral argument in your own case. Is that right? What was that like?
I did. It was really fascinating. I'm really grateful that I got the chance to go, because to hear the arguments of both sides, and then to have the justices ask questions. And I was actually able, because I understood the case so well, I understood what was going on in the arguments, and it was really fascinating.
That's very cool. So, Judge, we've been talking a long time, and at the top of the show, we mentioned that you're no longer an immigration judge, and you have retired yourself. But before you retired, there was a bit of there were allegations brought against you. This is from the San Diego Tribune in September 2019. Retired immigration judge fined for talking about political parties' immigration platforms from the bench. The San Diego Tribune quotes as saying that in March 2016, Judge DePaolo told a man in her courtroom who was facing deportation and a 10-year bar on returning to the United States that one of Hillary Clinton's campaign promises would get rid of that bar, but that Republicans were not likely to change it. I think anybody who knows immigration law knows that that's pretty unremarkable. This is the most unremarkable sentence I've actually ever heard. What happened with this? What was this about?
Yeah, I was doing a removal hearing for a young man who, very much like other young men who came into my courtroom, was brought here when he was just a child. He spoke English. He didn't speak any Spanish. He had a criminal record of some kind, although I don't think it was anything that would have made him a danger. And he had been in my courtroom two or three times. And the last time he came in, he said, "I'm not going to fight this anymore. I'm just going to go ahead and get deported," and because he was in fact subject to deportation. And in explaining to him the 10-year bar, you have to understand that the minute you walk across that border, because you've lived in the United States for such a long time, you have a 10-year bar. You can't come back for at least 10 years. And then you can only come back if you are given the legal right to come back. And then I said, it really depends. I believe I had seen a town hall meeting with Hillary Clinton where she said that if she was elected, that she would get rid of the 10-year bar. And so I said, you might actually have a chance to come back if that happens sooner than that 10-year period. But if the Republicans, are winners, then that probably won't happen because, I don't think there was any question that there was a great push for deportation. MSPB, who accepted the complaint from the Office of Special Counsel, said that I had engaged in political activity and that I had attempted to use my position as an immigration judge to impact the outcome of the 2016 presidential election. I think the judge who rendered the decision, was upset with me because I somehow did not accept it. It was a disagreement. I didn't find that anything, I had done research. I didn't find that anything that I had done was acting politically or taking some kind of political action. And I certainly was not attempting to affect the outcome of the 2016 presidential election.
It does seem, by definition, the respondent in front of you that day could not vote.
Right. He was not a U.S. citizen and he could not vote. But I understand that it's, that argument just didn't work with them. And I can see why it didn't. I just disagree that I was engaging in political activity or that I was trying to influence the outcome of the 2016 presidential election.
I think two things on this should be said as well. In that same San Diego Tribune article, Judge Tabador, who is the head of the Immigration Judge Union, which was recently disbanded by the Trump administration, but will probably be back under the Biden administration, I can only imagine. Judge Tabador was quoted with saying about this that in regards to non-citizens, when they don't have counsel and have to make a critical life and death legal decision about how to proceed next, it is absolutely incumbent upon the judge to explain the law to them. And at that particular juncture, the law was potentially going to change based on the election result. So that was the position of the Immigration Judges Union at the time. And, in preparing for this talk, I just did a little search. I get, the mechanism that I suppose that was the basis for all this is the Hatch Act, which is a serious thing and is something that should be complied with. But, a simple Google search, and this was a 30-second Google search, shows that in the last year alone in the Trump administration, Sonny Perdue, Kellyanne Conway, Ben Carson, Bill Barr, Mike Pompeo, Mike Pompeo, Chad Wolf, and Pete Navarro were all cited with Hatch Act complaints. And that Ben Carson, quote, penned an op-ed with Trump attacking the Biden dystopian vision of building low-income housing next to your suburban house. Mm-hmm. So the Hatch Act is serious. It does seem like it is considered by the Trump administration applicable to certain individuals and not others. That is one podcaster's personal opinion.
Yeah, no, I found it really to be ironic that the administration, the Trump administration, flagrantly violated the Hatch Act and by engaging not even in public, but on the news and made real public statements that simply said they didn't care if it was a violation of the Hatch Act. So it's ironic. It took them almost 4 years to do the case, and I had retired before the decision came out.
What kind of things were you seeing from the bench before you retired?
I think what I saw that most concerned me was the amount of violence that many of the countries in Central America are some of the most violent countries on the planet, and that people's lives have been impacted by the amount of violence in Central America, the gang problem, drugs and gangs, and a real burden to the civilian community. And I think the world just became a much more dangerous place year after year.
What changes did you see administratively within the immigration judge profession and within EOIR?
I think there was a real push to increase the numbers. I mean, there was judges were going to be required to do 700 cases a year, and so the pressure was on to take on more cases, to get decisions out. Many of these cases were primarily all asylum seekers, and then we had the program where the administration basically said, you're going to have to stay in Mexico, and they brought people to court from Mexico and weren't giving people the opportunity to find safety with their families in the United States. And then you have the whole issue with respect to the separation of children from their parents. And that's just, by any definition, it's appalling.
Yeah, that was happening in San Diego too. I believe a judge in the Southern District of California was Judge Zsa Zsa, I believe, was the judge who granted some injunctions on that policy. Before I let you go, and I really appreciate your time, what's your post-bench like been? What are you up to, and how are you finding it?
I'm one of those people who, I've worked my whole life, so retiring was a bit of a shock. I expected to feel really liberated and terrific, and read all the books I hadn't been able to read in 23 years, see all the movies I hadn't seen in 23 years. But I actually found it to be more of a challenge. I think when you're used to working every day and you have a lot wrapped up in the work that you do, to have that come to an end is a bit of a shock. So I've stayed busy. I've been training in the area of mediation with the Restorative Justice Mediation Program here in San Diego, and also with the National Conflict Resolution Center. And I really enjoy the whole idea of mediation and coming to terms with conflicts that provides people with the ability to find the best outcome for conflict. I'm really enjoying that. I also took the real estate exam, and I passed the real estate exam. So I'm a real estate agent. I hung my shingle with Coldwell Banker, and they're a great company with great resources. And I told myself I was going to give it a full year to see if it was something I was interested in pursuing. So I've kept busy.
Thank you, Judge. I think that'll be I think both things will be great, and especially mediation. With it doesn't seem like there's much room for agreement in immigration court just because of how the system is structured. So I think that if there's anyone who I would want trying to help me with a case reach a settlement, obviously in the civil context, I think you would be great at that.
Thank you.
Thank you for being on the show, Judge. Like I said, I've got a couple judicial mentors. I'm really lucky in that regard. Believe me, I know how lucky I am, and I consider you one of them. And I'm just really thankful that you were in my life, especially early on in my professional career, and that you took the time to be on the podcast today. And I hope the listeners like it too.
Okay. Thank you, Kevin, for getting in touch and inviting me to sit with you for an hour or more and go over life as an immigration judge. Totally.
Judge Zsa Zsa DePaolo, thank you so much for being on the Immigration Review podcast.
You're so welcome. Thank you.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.